right, so welcome everybody. So today we're going to have Susanna Sundby of Kennedy and Lords, who is a US-based patent attorney specializing in biotechnology, pharmaceuticals, sort of everything life science patenting, speak to us, and also David Reed from Bartle Reed, who is a European patent attorney, and they're going to also focusing on biotechnology, pharmaceuticals, life science, intellectual property, and they're going to talk to us about the differences between US and EU patent laws and make sure that everyone understands so that you're aware and really protecting your intellectual property in your startup. After this, if anyone has additional questions that occur to them later, please just feel free to reach out to your institution's technology transfer office and they can absolutely help you out.
Thank you. So I'm Susanna Sundby, and David and I came up with this presentation because we thought it would be really good for inventors and startups to understand some of the differences between US patent laws and European patent laws. Especially since filing in Europe can be very expensive, and it's good to know where, how certain things may affect your patent rights and could cost you, especially considering the expenses. Okay. So this is just a slide to show how, like, the basic themes of our patent laws and how they align with Europe. So on the left-hand side is the European Patent Convention. And you see I highlighted in orange some of the more important distinctions. In the US we have novelty, and then in Europe absolute novelty, which we will explain in more detail. Europe, you have to have certain types of support, and it's really more of strict basis. And in the US we have best mode and still the duty of disclosure, which you still must have in order to get a patent granted. But for the most part, some of our laws with non-obviousness and clarity, pretty much similar. And novelty in a nutshell for the U.S. right there in the first 102A1. That's the 1-year bar that's under our old rules, and it came through on the new AIA. And we do have exceptions. And we have exceptions to that rule of our 1-year bar with novelty. And then in green you can see that's any disclosures that were made within a year of your patent filing. And once again, you have exceptions there. And so I just wanted to put that up. You guys have heard, various patent attorneys, U.S. patent attorneys speak on novelty, and that there's always exceptions and how to get around those issues. In Europe, novelty is a little bit different. And
thanks. So in contrast, in Europe, we have absolute novelty. So an invention is only new if it's not part of the state of the art, and that comprises pretty much anything that's available to the public. There is a potential saving grace, a 6-month grace period for in certain limited circumstances when, for example, confidentiality has been breached. It is still possible to file a patent application in a lot of European countries, and that includes UK, France, and Germany. But the really important thing to bear in mind if such a breach of confidentiality has taken place is that you must directly file in each of those European countries of interest to you within the 6-month grace period. It isn't sufficient to file a patent application and then, I don't know, 12 months further down the line from that, try and claim priority. You've got to go into each and every single one of those countries within that 6-month period.
And so do all the European countries that are part of the EPO regional filing, do all those member states have the 6-month grace period?
They will have that 6-month grace period, yes. for that very, very limited situation. So don't make any IP filing strategy based on that, relying on that. It's just there to catch you if you're in a really difficult situation.
But if I have a disclosure, I can't, for filing a EPO regional filing, I don't have a 6-month grace period for that.
No, go direct to each of the national offices. So, what is a novelty-destroying piece of prior art? What's available? Well, it doesn't take much. It requires at least one person who's not bound, either expressly or implicitly, to keep it confidential, could at least theoretically have access to the piece of prior art, whatever that might be. And if that document is sufficiently described so that a skilled person could reproduce it, then it's considered enabling and novelty destroying. The key case in the UK, at least, and the one that everyone learns, is about a document that was placed in a library, so in one single library on the shelf for about a week before it was discovered and withdrawn. It was shown that no one had ever actually seen the document or taken it out of the library, but it was sufficient that people could theoretically have had access to that piece of prior art, and that was enough to render it anticipated.
And that's pretty similar to the U.S. laws on novelty and access to and the availability of prior art.
So coming on to inventive step, it's interesting that the European Patent Office has quite a formulaic approach, and it's termed the problem solution, and arguably it's relatively easier in Europe than it is in the US, overcoming obvious rejections. The approach is to identify the closest piece of prior art, step one. Step two is to formulate the objective technical problem for solving the issue. And then thirdly is to ask the question whether it would have been obvious for a skilled person at the time of filing that a solution to that problem would have been obvious. In contrast, so I was just saying, in contrast to the US, if an inventive step objection comprises a large number of references mosaicked together, then that's usually an indication of a weak inventive step argument.
Sorry, I was just trying to figure out the slides. So with inventive step is very similar to non-obviousness in the U.S. And there are differences. And with this, with inventive step, that we see the types of arguments one can make in Europe about with this problem solution approach, that there's really a fine line between the European type of problem solution approach and what I call taking the examiner's hand and walking them down the path of obviousness in the U.S. That a lot of times the reason and how they solve the problem, that the inventors went about solving the problem, is really the reason for obviousness in the U.S. And so there's a very fine line when making those arguments, and I just recommend caution in making those arguments to your European associates, just because some of those arguments can then be made and used for the U.S. in obviousness. It's just a fine line, and so be careful. With priority, in claiming priority to a prior application like a provisional, often you have to make a priority claim like that to preserve novelty and non-obviousness. and also to delay having to file in other countries such as Europe and other countries that you might want to file in that are not the U.S. So you'd have like a U.S. priority application, and then you file a subsequent application and claim priority to it. And the priority claims are very important.
So in Europe, the European Patent Convention provides for that priority and has codified it. So any person who's duly filed in a Paris Convention state or a WTO member state an application for a patent, or his successor in title shall enjoy, for the purpose of filing a European application in respect of the same invention, a right of priority during the 12 months from the date of filing the first application. So the European Patent Office, it's a particularly hot issue with them at the moment. Historically, they would never have reviewed the priority establishing application in great detail and just assumed that the subsequent application, the European application or PCT case, had a valid claim to priority. That's not the case now, and they are starting to increasingly examine the priority claim for PCT cases and European Convention cases. So there are a number of potential priority pitfalls, and the first is where there's been a change of applicant. So if you recall, the relevant article of the EPC says any person or his successor in title, and the EPO applies a particularly strict interpretation. So, for example, a daughter company and a parent company, if applicant A is the daughter company and they file the first priority establishing provisional application, for example, in the US on the 26th of October 2014, and then 12 months later a second application is filed, be it a PCT or a European Convention application, but the applicant is now the parent company, applicant B, the EPO will not recognize the priority claim and it will fail. So the first word of advice is to ensure that you assign the priority from the first applicant to the second before you file that second case and claim priority.
And so by saying it will fail, the priority claim will fail, and that affects the rights of the patent for the claims.
Absolutely right. It's the priority claim that fails, not necessarily the application, but who knows what kind of intervening publications have been made by the applicants themselves or by third parties during that 12-month priority period. And
so you might lose your claims because you don't have novelty.
Yeah, particularly if somebody's published a paper in that priority period, that publication will then become direct prior art for your application. The second pitfall, the date of the assignment, and this seems to crop up more frequently when filing divisional cases. Typically, US provisional will be filed, 12 months later a PCT application is filed, and then the European regional phase is entered in the usual way. And the EPO at that time will just assume that the International Bureau or the receiving office has made sure that the priority claim is okay, and that the relevant applicants are correct. When it comes to filing a divisional application before the EPO, say 10 years down the line, because of the speed at which they examine cases these days, they will expect you to file a statement identifying the means by which the current applicant derives the right to file the application in the first place and the right to priority. And at that stage, we often receive copies of assignment documents that have been dated either after the filing of the PCT application or during the priority period, both of which cause problems. If the inventor assigns after the filing of the PCT application, then the applicant has no right in Europe to file that application. And we are left in a difficult situation of trying to argue that we, or the US attorney, incorrectly identified the applicant on the PCT application forms, which, as you might imagine, is quite a difficult and long-winded process, and certainly no certainty involved in that. If the inventor has assigned during the priority period, and as we've discovered on the previous slide, the right to claim priority disappears, but you should be all right with the second application. So it's really a lesson to get your ducks lined up in a row before you file your provisional applications, and make sure you have those documents in place from the inventor to the first applicant.
And David, in all of these situations, we're talking about assigning the rights of the provisional application, the right to claim priority to the provisional application. So it's an assignment of actually the provisional application, not the PCT, correct?
That's correct. And so the third potential pitfall picks up on that the statement in the Article 87, which says it has to be the same invention. It's the same invention from which priority can be claimed. So in this particular example, we have the first application filed 26 October 2014 for subject matter A plus B. And then 12 months later, PCT application or European Convention application is filed with claims. The first claim is directed to subject matter A plus B, but the inventors have been busy during the 12-month priority period and have made an improvement, and so claim 2 is directed to that, which is subject matter A plus B plus C. Now, in this case, priority is absolutely valid and established for subject matter A plus B in claim 1, but for claim 2, there is no priority date. In fact, the effective date for assessing patentability will be the date of filing of the PCT application on the 26th of October 2015. So it's just a word of caution that if improvements are made during the priority period, that you ensure that your claims include subject matter which does have basis and therefore does have a valid claim to priority in the provisional application. Now, in some extreme circumstances, it might not have been appropriate to have a claim set with those specific claims in it, and so one useful thing to do is have an annex to the application and just keep the original wording of claims if you prefer it in provisional.
So if I understand correctly, claim 2 it would not necessarily be invalid so long as there wasn't prior art before the filing of the PCT or the European application that has a disclosure of A plus B plus C. It's just that it can't have priority back to the original first application because it didn't have support for it.
Exactly right. Exactly right.
So the priority best practices in the United States, it is so very important for the inventorship and applicant information to be correct. And it is absolutely necessary that when the tech transfer office or the patent attorneys ask for the executed assignments back by a certain period of time, it's absolutely necessary so we can get those recorded and on the record and have those by the time that we need them, before filing the PCT or the European application. And so immediately return those assignments back to the patent attorney or your tech transfer office. It's very important. I would also say it's very important for the application like the PCT, where it has the second new claim with A plus B plus C, that assignments are also obtained for that application because we may want to claim priority back to that also. And claim amendments are often necessary to overcome art and clarity rejections, but there are limitations on what type of claim amendments can be made after an application has been filed. So next we'll cover what type of support you have to have in the specification, and this is where there's a significant difference between the U.S. and EPO practice and the type of written description support and basis you can have for those types of claim amendments.
Yeah, so in Europe, I mean, the underlying principle is that an applicant shouldn't have an unfair advantage in being able to amend their application post-filing and to try to ensure certainty for third parties. So the relevant provisions in Europe effectively allow amendments that have explicit or implicit support in the original application as filed. And the application as filed in Europe is the specification, claims and drawings, and that may include some sequence listing data if that's incorporated in the application as filed. But it does refer to the original language of text, which isn't so much an issue for US applicants because you'll be filing in English. Certainly if you file a PCT application and then subsequently enter the European regional phase, then the application as filed is the PCT specification. And in very, very limited circumstances, cross-reference documents mentioned in the specification can be used. However, there are a handful of cases, and there's a reason for that, because the EPO are incredibly strict and do not rely on cross-reference documents really in the main. And if you are in that situation, then you're in a heap of trouble.
In the U.S., the application as filed is somewhat similar, but it's a little bit more flexible. The application as filed in the U.S. is the English language translation if filed as part of the original application papers. However, even if that's slightly wrong or needs to be fixed, we do have incorporation by reference where we can go back to the non-English priority application and correct and point back to that to bring that material in as part of the original application filing. Also, if it's a U.S. national phase application, similarly, it's the PCT application that is the application as filed. We can, in the U.S., cross-reference to documents and incorporate them by reference. If we properly incorporate them by reference, such as sequence listings, other documents, and if it's properly done, it is part of the original application, and we can rely upon those disclosures and those documents to be part of our application in the U.S. So that's really different in Europe, where we can't rely upon those prior disclosures, and often that can be very problematic.
So in Europe we have strict basis effectively, despite having said that amendments can be based on explicit or implicit disclosure. The guidelines to examination set out that there's no requirement to use the exact wording from the application as filed.
But in the U.S., we see that it's basically the strict basis is word-for-word support. When we're in our European applications that we filed, that if we try to amend, our European associates come back and say, no, that's not really supported, and they're basically looking for word-for-word support. It's likely because of the requirement for implicit disclosure, which is a little bit more strict than one would think.
Yeah. So the new guidelines, which were issued in November 14, have a definition of implicit disclosure, which is the clear and unambiguous consequence of what is explicitly disclosed. So there's not a lot of wriggle room provided.
Right.
And this leads on to the inescapable trap. So the section of the European Patent Convention that provides for strict basis, says that a European application or patent can't be amended to extend the scope of protection beyond that as originally filed. When it comes to a granted patent, if it contains a feature that was not disclosed in the application as filed, and if the removal of that feature would extend, i.e. broaden the scope of protection beyond that which was granted, the patent must be revoked.
And revoked is invalidated, no longer valid, gone. So that's, I understand, as a U.S. attorney, sometimes, in front of the USPTO, we try to push the envelope a little bit for some of our claim amendments and have, not necessarily word for word support, and sometimes U.S. applicants that are familiar with how the U.S. patent practice works try to do similar things in Europe, and that's where you could run into problems that
you could, and it's not just universities that get themselves into this difficulty. An oral lesson. So one of Pfizer's Viagra patents, so it was the use of GMP phosphodiesterase inhibitor for the manufacture of a medicament for oral treatment of erectile dysfunction. The word oral was added to the claim during prosecution. So the application as originally filed contained two teachings effectively. First was the use of compounds of a defined general formula, and the second was the use of compounds defined only by their function, their action of enzyme inhibition, which lacked a general formula. Unfortunately for Pfizer, the administration of the structurally defined compounds was originally said to be oral. However, the administration of the functionally defined compounds was not originally disclosed. And so during prosecution, they had an amendment to include oral administration into the claim, which the examiner accepted. But during opposition, their opponent brought this to light and argued that there wasn't a strict basis in the application as originally filed, and the opponent won.
in oppositions in Europe is like what we now have in U.S., the post-grant proceedings, where others can come and attack a granted patent and say that they shouldn't have received the granted patent for various reasons. And so in Europe, the opposition is where a third party comes and attacks the granted patent, and poof, it can be gone.
So their patent was revoked.
Right. So avoiding the trap, what should we do to try to prevent that from happening, where you spend all this time and money getting your European application granted, and then all of a sudden it's invalidated, essentially. Set forth all the possible combinations when working on the draft application. Draft application, we're talking about the first disclosure, if possible, the provisional, but the next best thing, for U.S. applicants, it's usually your U.S. Utility application or your PCT that then becomes the filing for in Europe. So set forth all the possible combinations in it. Don't try to get away with amendments that are acceptable in the U.S. If the European attorney says, well, we can try, but can you point to me in the specification where that says it exactly, and it's not word for word support there, I would really just go with what the European associate says and the type of language that they recommend, because otherwise your patent once again could become invalidated. And treat the strict basis requirement in Europe as quite strict. Word for word support.
Sound advice.
So patent eligible subject matter, a lot of us in the U.S. have been getting all wrapped around the axle, I guess, in what is patent eligible in the U.S. and what is not eligible. And right here you can see on the left-hand side what Europe says is patent eligible subject matter in the U.S. And these are just sort of our basic statutes summarized. So
in Europe, we have a negative definition of an invention in terms of what cannot be regarded as an invention that's patentable. They include a number of things: discoveries, scientific theories, and mathematical methods. So if it's found in nature, then that's potentially a problem. Obviously, if it's isolated, it's slightly different. But aesthetic creations, scheme, rules, methods of performing mental acts. So methods of doing business, which is why Europe has not been a popular area with business method patents for quite some time. Programs for computers and the presentation of information.
So in the U.S. we have a great deal of uncertainty about what is eligible. And in the U.S. we have judicial exceptions to patent eligibility. And so abstract ideas themselves are not eligible for patent protection. Laws of nature and products of nature are not eligible, and natural phenomena. It's not explicitly recited in our statutes saying that these are not eligible, but they have become these judicial exceptions, these carve-outs to our statutes. And right now in the U.S. it is those judicial exceptions are under great controversy as to what is the scope of those exceptions and what falls underneath it. Underneath those exceptions and are excluded from patent protection. And it's questionable right now whether diagnostic methods and purified natural products are eligible. At least I don't recommend that you not file or you not pursue on those. It's just it's really based on the given circumstances and the type of data and how one goes about claiming that type of subject matter. So don't just like assume that they may not be patentable, patent eligible, and so therefore you don't pursue it. One good thing still, treatment methods are eligible in the U.S. And in Europe, though,
the bad news is that treatment methods are patentable. The basis for this being that a physician or medical practitioner should be able to treat a patient, and you shouldn't go around suing them. So methods of treatment of
you said but.
Yeah,
sorry, did I skip?
But crucially, the provision excluding such methods by surgery or therapy or diagnosis are only applied to, do not apply to products. So it's only the methods which are not patentable. The substances, so drugs and medical devices, are patentable. And in Europe we have an accepted structure of claiming the products to effectively methods of treatment or diagnosis. And they're frequently called medical use claims. So for the first time that a composition is discovered as being useful in medicine or treatment of some condition or disease, the accepted language is a first medical use claim, which is compound X for use in therapy.
So these use type of claims, they're more of a legal workaround. So you're not actively saying a method of treating, but they're equivalent to our treatment claims, so to speak.
They are. It is a legal workaround, and our sort of non-life science, medical, pharma colleagues are frustrated that they can't use similar language in other technologies. So for first medical use, it's quite broad. It's the known composition for its new for use in therapy. For second or further medical uses, the language becomes more restrictive. So previously we had what we call Swiss type claims, which are use of a particular composition for manufacture of a therapeutic for a particular disease. When the new EPC came out, which is nearly 10 years ago, EPC 2000, they switched that position so that you could use language, more appropriate use language, so it's compound X for use in, and then you put the specific therapy or disease that you're treating. And the types of inventions which can be protected by that kind of language include situations where you've got a known pharmaceutical composition and you've got a new indication. You've got a known pharmaceutical composition, known indication, but a new patient group. You've got a new dosage form or a new dosage regime. So there are lots of options available for getting protection in Europe, despite the fact that the methods per se are excluded from patentability. The one thing to really remember with second medical use patents is that the data needs to be strong.
Right. And so like in the U.S. when we're writing applications and we have, it might be questionable whether or not the composition is actually novel or non-obvious. Would you recommend that it would be a good thing to do to add disclosure about the second medical use and the data and think about the different dosage regimens? And
absolutely append that those kinds of claims and that kind of description at the end of the application, so it gives you options in Europe. So one sort of example of the practical application of second medical use claims, there was a recent decision in the UK where there was a generic, the original pharmaceutical composition was off patent, but there was an existing second medical use patent for the use of that compound for treating pain, and so the holder of the second medical use patent was desperately trying to stop the generic selling in Europe for that patented use. And one of the problems that they had is that despite the fact that the generic had a skinny label carving out the second medical use, so stating that it shouldn't be used for treating pain, doctors tend, in Europe at least, tend to write their prescriptions generically in the main, and almost never put down the specific indication for which the drug's being prescribed. So practically, one might argue that a second medical use patent is useless. However, the judge in this decision, realising that, issued an order to the NHS, which provides the bulk of the medical care in the UK, ordering that they had to specifically prescribe the innovative drug for pain and to avoid prescribing the generic for treating pain.
Very interesting.
So good news.
Right. So before we go on to the quiz questions, what are some of the most costly mistakes that you see coming in from, say, foreign origin? So foreign origin, something coming in from the United States or other countries. What are the mistakes that they make that cost either the rights or they're expensive to fix in Europe?
In terms of cost, the biggest is the number of claims coming in. So in Europe, you get 15 claims included in all of the fees. And if you want anything more than that, you have to specifically pay a separate claims fee. So if you have specifications coming in that are 50 to 100 claims long, then two things happen. One, you either get a very large bill from the European advisor for the claims fees, or two, you get a smaller bill for the European Patent Attorney amending the claims down to 15, or to try to deal with that. So that's a particular issue.
So about how much more is it per claim over the 15?
It's hundreds of dollars per claim.
Wow. Another example of costly differences?
I would say on the added matter side of things, one of the issues is that with feature combinations in particular, it can get quite thorny. So if you have two general lists in a specification and then some language linking those two lists together, if you start cherry picking from those two lists, the EPO will say this is a new invention.
So it's more about the strict basis of making particular combinations, so selecting what we call in the United States when we're referring to the strict basis in Europe, the selection of the invention, where you're picking, you know, a specific member out of one list combined with a specific member out of the other list. And unless you have, what you're saying is unless you have the exact written description support for that particular combination, that is very problematic, where a claim to that could be revoked from.
Absolutely. And so when filing PCT applications, and I know that there's the culture of filing a provisional without claims, but if you could have the important feature combinations in that provisional application, assuming you know what they are, because often that's not the case. So you can then claim priority for those specific feature combinations. Or in the PCT, if you use European style multiple dependent claims, then you are providing lots and lots of feature combinations in the claim set for relatively little money, because you don't have to pay the claims fees at the PCT stage.
So, so the improper multiple dependent claims, or you have multiple dependent claims dependent upon other multiple dependent claims.
Correct.
Right. Okay, so I guess we'll do the quiz questions, and then we'll have questions at the following the quiz questions. So, number 1, priority claim made in a European patent by a university is invalid if the inventors haven't assigned the priority application to the university. True or false? And the answer is true. Your priority claim will be invalid, and that may also make the claim that the patent claim invalid, or as they say, revoked. Second question. The claim granted by a European patent examiner is valid and cannot be revoked even if it lacks explicit written description support in the specification. True or false? And the answer is false. It can be revoked. It can be invalidated. It doesn't matter that the European examiner granted it. The next question. You can get a patent on the same inventions in Europe as you can in the United States. True or false? And I say false. David wants to say maybe. It's questionable because we do have the difference in claim language and how you go about claiming it, and especially, you know, we have art and eligibility up in the air. So I say false. David wants to say maybe. But there's a way, and so always, I mean, here's something very important, is that there's differences, and there's differences in how things can be pursued for patent protection. And if you think the market in Europe is important, you do want to get the advice of a European patent attorney, and usually, especially with universities and research institutions, it's through the U.S. patent attorney who then consults with the European patent attorney that they work with to help guide how to pursue that protection. So if you think that there's going to be a big market and it's important, look into that sooner than later so that we can draft the applications and plan accordingly. And so there's David, picture of David so you know what he looks like. And then me, there I Let's go. Questions. So. Are there online questions? Oh, okay. So we'll just. So do you have another example of what costly mistakes you see coming in from the U.S.?
The issue with the date of assignments is crops up every month. It's alarming how frequently we're filing divisionals in Europe, and then all of a sudden we're asking awkward questions about the date of assignment documents, because up to that point everyone just assumes that the situation is fine.
Well, say I have 5 inventors and they're all supposed to be assigned to the University of California. However, I only have assignments from 3 inventors, and my 1-year bar date by the time I have to file the PCT is say today. What do I do?
Then you file it in the name of the inventors.
So I file, because I have some assignments, so you're saying I file in both UC and then the inventors that I don't have the assignments from, that they're the applicants then.
And then everything is fine, because we can start back at the inventors and we can see a clear chain of title from them to whomever ultimately files the PCT. And then once the PCT is entered, is in the international phase, you can tidy up the assignment issue during that time to save costs on doing it during the national or regional phases.
Right. So it's about accounting for all the rights.
Absolutely. Yeah.
Is an absolute novel invention an invention that uses prior art as data?
I think that there may be a little bit of confusion. Absolute novelty is about whether or not there's prior art before filing an application on an invention before that filing date. So in some countries like Europe, in order to be able to have an invention that's deserving of patent protection in foreign countries, it has to have absolute novelty, meaning that there is no prior art prior to filing that application that would read on that application that preceded the claimed invention. If I don't understand the question correctly from that person, if they could send another email or a webinar to clarify, or if you'd like, just contact us and we can further discuss that, offline. More questions? Well, we have OIP here. I mean, what have you seen? Like some questions from your inventors or issues?
Oh, 1 second. I'm
sorry to put you on the spot.
Yeah, no, I'm really not a European patent
well, no, but
expert.
do you see questions from your inventors?
Well, I think people get confused because it is different, and how do you manage that, and understanding the claims. I got confused when you were talking about dependent claims. So when you're counting the 15, is it 15 independent claims or 15 any claims?
It's 15 claims in total.
Okay.
And it gets even more frustrating because you're only allowed 1 independent claim in each category. So 1 method, 1 process, 1 use.
Oh, wow, okay.
They are particularly hot on that at this moment in time.
And so if you have more independent claims that you feel are important within a category, do you then have to spend the money to file multiple patent applications?
So we have, effectively, yes. There is a way, there's a very slim argument for trying to argue that they may be interrelated in some way, and then we have to explore that argument in detail. But the examining division is very reluctant to accept those kind of arguments at this moment in time. And so effectively, you are in a situation where at some point during the prosecution, if you want protection for those other independent claims, then you're looking at filing a divisional application and the associated cost of that.
And if you could elaborate on the associated costs, because I think some U.S. Applicants are rather shocked with the cost of filing a divisional application. That actually, you know, a regular European application, that's expensive in and of itself, but a divisional is especially expensive because?
Well, because the EPO likes to receive annuity payments whilst the application is pending, in contrast to the US and pretty much quite a number of jurisdictions around the world. So when you file a divisional application, you have to pay all of the renewal fees that accrued from the filing date.
From the parent.
Of the parent.
European.
So you can be in a situation with the EPO, particularly in our field, where you are having an application that's 12 years old and you're filing a divisional paying 9 renewal fees. And so it's easily $25,000 for the filing fee.
So it can be very expensive, and just the application fees, the government application fees are about.
That's almost exclusively the government application fees. So you'll have attorney fees on top of that as well.
Right, but I just want some of the participants to understand even just the cost of a European application, the government filing fees for.
They are somewhere. They're about €3,500 for a convention application. So that would pretty much translate to, you know, $3,000 to $4,000, I imagine.
Right, with just the government fees, and that's like 3 times as much, at least 3 times to 4 times as much what the U.S. application fees are, and then you have the annual annuity fees. So it is expensive. I guess.
As for the timing on a priority claim made in an EP patent, did you say you can make a priority claim in an EP patent and then afterwards get the missing assignment? At what point will it be too late to get the assignment? Or must the assignment be in place before the priority claim is made?
The assignment must be, and thanks, the assignment must be in place before the priority claim is made. So effectively before you file the application, from which you'll put the claim to priority in.
So that actually raises a question for me. So are you like, say I file a European application and I don't file a priority claim, I don't claim priority to my U.S. provisional at the time of filing, can I actually later file that priority claim after the?
Okay, prior to the publication, then you can try to argue that the priority claim has been omitted and it ought to have been included in the application documents. But that doesn't change the fact that the assignment itself has to be in place before the filing date of the European case. So if you somehow, something's happened and the priority claim wasn't included in the application documents and the application forms, then there is a mechanism for doing something about it. But you still need, the facts don't change. If that assignment document didn't exist beforehand, you've got a problem.
So what you're saying, I can't not file my priority claim because I don't have my assignments in order, and once I have my assignments in order, then file the priority claim because I then have the assignments. You're saying I can't do that. The assignments have to be obtained before filing the European application.
Or just, and I do this myself, if the documents aren't available, then the application's filed in the name of the inventors or the applicants who are of record.
And once again, because a lot of times you go through the European regional phase through the PCT, you're saying that the assignments all have to be in order at the time of filing the PCT application.
That's correct.
Great, thank you. And I guess if anybody has, once again, any questions, reach out to your tech transfer office and talk to them, ask them questions. Don't delay where it might be a problem. And we appreciate you taking the time and happy to help.